To introduce our first, one of our new members, Miss Marilyn Morgan. She's joining us here today. So we look forward to her participation throughout the process. I won't ask you to give a speech or anything, so we'll just, unless you want to. Okay, well then we'll jump on in.
Unless you had one prepared.
All right, well, notice of March 23rd, 2018 meeting of the Court Reporters Board was posted to the Court Reporters Board website, March 16th, 2018. If I may, I'd like to do a roll call. Britton Collins,
Present.
Ken Gibson, John Rambo,
Here.
Marilyn Morgan,
Here.
Ken Mansfield,
Present.
Earl Houston.
Present.
Chair, we have quorum. If we can, we'll go on, since we've already done the notice of meeting, we'll roll on down to the agenda. If you look on your iPads, you'll notice there that we don't have a full day's business, but we'll cover some pretty important items. Is there anything on there? If that agenda's fine, if somebody would make a motion to that effect and second, that'd be great. But if not, we can move that around as well at the will of the board.
I'll move that we adopt the agenda as presently stated.
I'll second that.
And if the executive director will call the roll, please.
Yes, sir. Britton Collins,
Aye.
John Rambo,
Aye.
Marilyn Morgan,
Aye.
Ken Mansfield,
Aye.
Earl Houston. All right, thank you. If we can, we'll move on down to the September minutes. I trust that you had an opportunity to look at that and to observe that, and we'll welcome any edits or discussion in regards to that.
I did have one edit that I would like to recommend in the director's report. It makes reference to me expressing an interest in reallocating net surplus into either a reduction in licensing fees
Yes, sir.
or initiatives like issuance of a court reporter ID or court reporter fund. I don't recall having expressed interest in allocating those funds to the court reporter IDs. I have for a long time been a proponent of the court reporters fund. So I don't recall having said that about the court reporter IDs. We had a discussion about the IDs, but it was more in the general sense of should we sanction the issuance of something like that. And I think there had been a request by maybe one of the trade groups to do that or something. But so I would recommend an edit to the minutes to remove the reference to the court reporter IDs in that sentence.
How would you like to do that edit so we can vote on this? We can always, of course, whatever edits we do, we can bring it back and vote on it. But would you like we can remove expressed an interest and discussed, or
Well,
the board discussed? Perhaps the board discussed the possibility of reallocation of significant net surplus. How about that? Would that work?
I think that would be appropriate.
Okay, very well,
I move that we make that change.
very well.
One thing that I've noticed that it's talking about indigent criminals. There's already a provision, isn't there, for indigent criminals for the state to pay their costs?
I think the criminal transcript costs are just subsumed within the cost of the criminal trial, unless I'm mistaken.
State bears that expense usually.
I agree.
I was thinking this would be more along the lines of in civil litigation.
Correct. On the federal level, they're provided by the federal courts, and in the criminal courts, they're provided by the court as well. So I think we're only talking about civil litigation.
Civil litigation.
I agree.
That was my understanding as well, and it says criminal, so I just wanted to note the clarification. It
strike,
should be for civil litigation instead of criminal, because
strike
there's already a
criminal.
provision for criminals
Okay, very well.
proceedings.
We'll strike criminal and then put civil. And then also, the board discussed the possibility of reallocation of any significant net surplus into either a reduction in licensing fee or initiatives like issuance of court reporter IDs or a court report fund used to pay the cost of the majority of indigent civil transcript costs and official court reporter salaries. Was that suit?
There are no official court reporters in civil court. They're all criminal court, and they're under
Like that
the
altogether then.
AOC.
It should just
Yeah.
be court reporter, probably.
Okay.
Official reporters are salaried by the state or the federal government.
So indigent criminal, or excuse me, civil transcript cost
And court reporter
And-
salaries.
reporter.
Fees might be better since there's not a salary
Court reporter fees. Very well. And per diem cost. That get it done? All right.
That sounds good to me. I think that comports with the discussion we had.
Judge Rambo, would you like to amend your motion into that regard, or do you have any?
Yes, my motion is to make those changes to the minutes.
Very well. Do we have a second?
Executive Director will call the roll, please.
Britton Collins,
Aye.
John Rambo,
Yes.
Marilyn Morgan,
Aye.
Ken Mansfield,
Aye.
Earl Houston.
Aye.
All right, thank you. If we can, we'll move on down to the director's report then.
Up the minutes, I just moved for the minutes to be amended.
That is correct.
I didn't know if there were any other changes.
Okay, very well. If we could, do we have a motion to that effect then?
I'll make the motion, we adopt the
Okay.
minutes as amended.
Second that motion.
Thank you, sir.
The Executive Director will call the roll, please.
Thanks, sir. Britton Collins,
Aye.
John Rambo,
Aye.
Marilyn Morgan,
Aye.
Ken Mansfield,
Aye.
Earl Houston.
Aye.
All right, thank you. If we will, we'll move on down to the budget report then, or the director's report, and we'll start with the budget report. If you'll notice, the first one is just the fiscal year. We meet twice a year, so obviously we want to take this as an opportunity to cover all that's the trending for year end, and then drill down further into the monthly trending as well. If you'll notice there, under expenditures, we have you got total expenditures of 2,000, just other expenditures, but then the grand total of 9,000. So you've got payroll 7,000 roughly, other expenditures about 2, to grand total of 9,000. You've got some other cost backs as well, such as administrative, investigation, legal. You notice legal's a big piece of that. Anytime we do the complaints or the investigations that go along with that, that's by the billable hour. So the time spent on that, as you know, can start to rise. So you see the that reflected there as well. So the total cost back is 10,000, which brings us roughly total expenditures of roughly about 20,000. So on the opposite of that, we've got licensing revenue. As you can see, was 23,000 roughly. Case complaint revenue about 150. So net revenue of about 22,000, which gave us a fiscal year balance of about roughly $2,500. The prior fiscal year reserve, $140,000, which that added to the fiscal year balance gives us a reserve balance of $143,000. Now it says after core expense. One of the things that I was going to discuss, and we'll get into that, I guess, later. Well, I guess we can do that now. We'll just cover the core update, since that's pertinent to the budget. As you know, right now all the licensing data is in a Access database, and we're converting that to our online system, and just in time too, because as you know, this is a renewal year. So that'll be very important to really the efficiency there, but also the tracking too. As you know, with the Access database, there's opportunities for some hiccups that could be problematic for our licensees. So to avoid that, that safeguard is to put them in our core database. Core is our comprehensive online regulatory and enforcement software. That's what it stands for. And it's basically, we track our complaints there, investigations there, everything is right there. And so at your fingertips, you can keep up with all that. And then plus the historical too. So you can imagine no more paper files. And so we're gonna have to migrate all that into that system. We were thinking, after talking to our vendor, that it was the cost to do that would be roughly $80,000, which is, even though we have a reserve balance about 143, that's significant. But working with our IT staff and working with our administrative manager as well, who did a lot of the testing for us, we were able to get that down to 40,000. So we were, pretty excited about that. We were expecting to kind of take a hit, so that didn't happen as we originally expected. So we're happy about that. So we're on this side of it. All that migration is going to happen. All that data is going to be migrated into Core over the weekend. Matter of fact, I was transferring a lot of that information. I'll be transferring a lot of information to a USB drive and then for migration over the weekend. So that'll be happening today. We're going to try to get those renewals out to everyone a little early to kind of get them used to the idea of an online renewal and to walk them through that. We've also got the Tennessee Board of Court Reporting Annual Convention on June, and I'll be going to that to speak to them to kind of alleviate any concerns or fears they may have in regards to that system and walk them through registering and renewals and what that looks like. So I think they'll be pleased with the outcome of that when they see, it is very user friendly, and of course there's plenty of support as well if they have any questions as they go through that. You'll also notice, so we can shift back to the budget.
Question,
Yes, sir.
the $40,000 cost is a one-time
Yes, sir.
upfront setup fee, right?
That's correct. That is
Okay,
absolutely correct.
And then are there going to be ongoing maintenance fees associated with it?
There's general Edison expenditures,
That's-
such as IT,
That's
internal.
subsumed within that.
We own that system core, and so
We've been getting, historically, since we moved over here, we've been getting those Edison chargebacks. And will those remain the same after the integration to core, or are they going to go up?
it would be, if it went up at all, you're not looking at $10,000-$15,000 type bills. It'd
Okay.
be incremental. You're looking at, what the billable hour of an IT specialist within our in-house. So that's nominal compared to, getting a vendor to do some sort of upgrades or some software enhancements. So, and that's what we're talking about here. So I'd be surprised if you'll see anything significant on that front at all. Good question. Thank you. If we look through the trending of the monthly report, as you know, this is an off-cycle year for renewals. Every renewal cycle, we're always typically in a net surplus, but we run a net deficit pretty much for all the year on the off-cycle. Obviously, just because expenses are going to outpace revenue because you're not bringing in licensing revenue. That's pretty common. We're on track there. We don't see anything there that's alarming to us. That's atypical of our historical experience, but as it stands now, that's kind of where we're at. So we'll just look at the last month. It looks like brought in revenue of about $1,000, expenses of about $1,600, which put us in roughly about $600 in a deficit. And even our deficits aren't alarming when you look at. We're not looking at, I don't think one month we had over $1,000. But other than that, I mean, there's nothing that has caused any alarm, at least from the budget standpoint. Does anyone have any questions in regards to that?
Can I ask one question? One question regarding the system that's going in place?
Yes, ma'am, please.
Okay. Will reporters be able, how will reporters be able to enter their CEUs? Will they have to still submit them and provide proof of them, or will that go in online?
All of that will be online. They can scan that into the system either as an attachment, or and if they're having problems with that too, they can forward that to us for us to attach internally. But typically, it'll just be when you go online, if you were sent an email and you hit the attach button, the paperclip down there, and then it uploads, same kind of system. It'll walk you through step by step what they're requiring, and when you get to that portion, it'll request those CEUs, and then they'll upload those and report what it is that they're doing for our audit. Good question. Any questions? Okay. Also, I wanted to take the opportunity to discuss the photo IDs, the scanner. We kind of talked about that a little bit last meeting, discussing that. I know that's something that a lot of the court reporters would like, something that's helpful, coming in and out of the courthouses in that regard. So there's a lot of discussion. Of course, we have to balance that with the budget, with the mandate as well. I mean, obviously, if there's, as a courtesy, there's some discretionary spending that would be permitted. Some of that we were trying to watch really to see what CORE would do. We wanted to lapse the renewal cycle as well to see if that's as robust as we've experienced in the past as well. In the interim, Executive Management has decided not to do the photos IDs in the immediate. Of course, we'd be free to revisit after the renewal cycle once costs have leveled off. Now, the big cost leveling that we're talking about was CORE. That piece, that's a heavy piece. That's dispatched, and we feel really good about that. That though we're not going to see any our stark increases in spending. So, the board at some point, if they decide they wanted to continue to pursue it, they could. But right now, in the immediate, the executive management has decided that that's not an option that they would pursue at this moment. disappointing to, I'm sure, some of the court reporters that have been looking forward to that. But doesn't mean that we can never do that. Just something that we'd have to, I guess, have either continue discussion about, or if that's something that the board feels strongly about, and then they were to make that determination, then they could, of course, express that, and then we could revisit. But right now, that's where it lies.
What is the estimated cost to do that?
You're looking at scanners, or I think the big cost will just be labor, really. Entry and working those now, but you're looking at the scanners themselves, or if you get it, roughly about $2,000 is the scanner, just the scanner. Supporting, incremental, you're looking at a few $100s for material. Probably, I bet you could, for all of them, just the material, you could probably do it for roughly around $4,000. And then, of course, just whatever labor would be associated with that. I don't have any projections as far as what the labor would take to do that. I imagine there would be a steep learning curve. It'd probably be slower at first, obviously, but I think we could probably work in some efficiencies if we were asked to do that.
Card does come in handy. I have one, member of the Tennessee Judiciary. If I'm in another county that's outside of my district, I can show that to the sheriff when I enter the courthouse. We have, of course, judicial conferences, and we're all there, and the state AOC staff is there, so that's when they make our IDs for us. I would think that one option would be to make those. But I think the trend that we are seeing across the state on courthouse security, dollars or $2 million in grant money that the General Assembly handed out last year for court security went to a lot of counties. All the court security committees, they're now up and running and looking at policies of banning pocketbooks and briefcases and all that. And one of the continuing discussions is to make sure that we can identify who our court reporters are. The attorneys will know them, but a lot of times the sheriff's deputies don't. And then the court reporters are trying to get a pass or an excuse from a judge or a circuit court clerk or clerk of master or something. If we had an idea, I think in the future it's going to be handy for court reporters and counties.
I agree with Judge Rambo. It's really important to reporters, from what I've heard, that they have some identification that's more than just paper. It seems like a fairly small cost. When you were talking about conventions and the such, Tennessee court reporters will have their convention in June. Is there any possibility something could be set up then?
I have carried my old photo ID, and I've carried my new ID too. Comments I always receive is the photo ID is out of date. So it would be very important.
One thing we can do just to kind of inculcate that and memorialize that, if that is something the board would like, instead of us, generally saying that would be their interest, I've seen other boards before vote on a statement saying that, we would like this, or that they kind of expressing their will in memoriam. So if that's something that you decide that you would like, that would be your interest, and that would be something that would be that you'd like to pursue, then you could vote on that. Of course, then we could pursue that further, take that up the chain.
What for the attorneys? What I know you've got the state issued card as part of the judiciary, but the attorneys themselves, what we typically use to get into most of the courthouses is our Board of Professional Responsibility card, which is sent to us by the Board of Professional Responsibility as part of our annual renewal of our license. We renew our license, we pay the professional privilege tax, et cetera, and they send us, a little pocket-sized card that you put in your wallet or whatever. There's no photo on it. It's just got your name and the valid dates for whatever that year is. It's never had our photos on it, and I've never had any trouble getting into any courthouse in the state using that. And it's literally just a printed piece of paper. So if we're talking about costs, and that being the hang-up on this. Do we really need photo IDs? You know, I've probably gotten into 30 different courthouses with a piece of paper with my name on it issued by the Board of Professional Responsibility. Would something like that suffice? And again, going back to the conversation that we had before, the last time that this was discussed, we as a board have absolutely no authority to mandate that any of these courthouses accept any form of identification that we issue. And so, you know, all we can do is provide something if we decide to provide it. And if the courthouses take it, great. If they don't, sorry. But do we need to go to the extra expense of having a very flashy card, or can we just have a piece of paper, an official piece of paper that's issued by us as the board, and basically a pocket-sized license that you can carry around and
You already
show?
have that.
And so you
They
already
have that.
and that doesn't work.
I think what I'm hearing from court reporters is that, you know, the dues that they pay, they should have a photo ID. We had them at first. We had them when the other board had them, and then they just dropped it. I think it would help with identification, you know, when we do go into courtrooms.
I think the difference may be that they may encounter, say, a lawyer is, let's say if they took one of these and slipped that in there. A lot of times, the court reporters get there before the trial. They have to go back.
If you could speak in the mic, I'm sorry.
I am sitting far behind. The attorneys, usually the judges know them, or they go to the clerk and someone's escorting them around. The court reporters are kind of by themselves. They're going in there, they're setting up equipment in the courtroom lots of times before the courtroom is even open to the public, and they're dealing with sheriff's deputies and not so much court personnel, which makes it a little easier on the lawyers, because you can get a hold of the judge's secretary, or the circuit court clerk will know you. And if they could just have this, because at least I know in my most secure courthouse, I have 4, the court reporters cannot get to their area through the courtroom. They have to go in the back corridor, and right now the sheriff escorts them everywhere because none of the deputies know who they are, and that's just the way it works.
And we're not, reporters aren't allowed to bring in handbags, personal, you know, things like that. So lots of times we just pull our card out and put it in our pocket and run into the courthouse. Well, a piece of paper can get lost much easier than a laminated card. That's a small concern, but it's a concern.
And everything seems to be going these days to photo ID. So I think it's a great idea. You even have to show a photo ID.
Well, if someone would like to just make a motion to that regard, that is their interest, then we can, of course, memorialize that and then take that up the chain then.
I make the motion that we allow you to draft a statement that reflects that if it's financially, feasibly, if it's financial cost in manpower and equipment and time and implementation, that the benefit of having a court reporter identification card photo is important, and it's the board's position that if that criteria is met, that they should be issued. That's our recommendation.
Do we have a second on that?
I'll second that.
Executive Director, call the roll, please.
Britton Collins,
Yes.
John Rambo,
Yes.
Marilyn Morgan,
Yes.
Ken Mansfield,
Yes.
Earl Houston.
Yes.
All right, thank you, board. I want to make sure I get those words. We can always go back and look at it, but I want to capture it, so I make sure we express exactly what the intent was. Okay. I I think we're ready for the legal report. If Mr. Gregory or Miss Ashley Thomas would like to jump in there.
Oh, I just wanted to introduce to the board the litigating attorney for the Board of Court Reporting. It's Mr. Dennis Gregory. I know the last time we met, it was Miss Lindsay Shepard, but she has left state government. She's in the private sector now. Mr. Gregory will be handling all the complaints for this board. And I believe you all received the legal report beforehand. Typically what Dennis will do is he'll read out the complaint number, give you a couple minutes to kind of familiarize yourself with it, ask any questions. He'll read the recommendation into the record, and you all can vote on it as you see fit.
Gregory for the agency. Just started with number one. The case number is 2017-9. And again, if you wanted opportunity to or if you already have reviewed it and have any questions, see if I can entertain those now.
Anyone have any questions?
Well, it comes back to the point of being an official court reporter. It mentions in the complaint.
Right.
And when the board was originally established, the requirement of being on the board is we had to have one member be an official court reporter, which was defined as an employee of the state of Tennessee. And so there's that.
And I think with this complainant's, the point the complainant made, I believe, is that this individual was a state government employee but not a court reporter. They retired from that position, just to give you a little background, just a little chronology, roughly in 2006. Then they applied to be a court reporter under the grandfathering clause in 2010. So in that interim period, they were doing court report. They were providing court reporting services of some nature, but not as what I guess we could say an official court reporter. But they were doing court reporting duties. And then when they applied for the to be a court reporter, and at that time, of course, it was under the Administrative Office of the Courts. And the individual did provide their copy of their original application and provided the affidavit from a judge that would have worked in the same circuit that she was an employee of. The judge and the application, here's where, and I think I probably should have included this in the legal report as I go back and look at it. The affidavit doesn't mention anything about having any knowledge of the applicant's time as an official court reporter. It only says I, and then the individual's name, state that the above named individual performed court reporting duties for me on or before July 1st, 2009. So it doesn't, the application or the affidavit itself doesn't even mention official court reporting or that the person had worked as an employee for the state. So in this case, the judge who signed off on the affidavit vouching for the person, for lack of a better way of putting it, wouldn't have even had, to say the individual had worked for them or they had known them in an official court reporting position. The complainant obviously is another court reporter, so this, you can sort of draw your own conclusion as to how they filed the complaint. And I don't know whether or not that the time issue is also, remember, this would have been an application that was submitted in 2010. This complaint was filed roughly, sometime in 2017, a little latter half of 2017. And I know we've got the statute of limitations about 90 days. Arguably, I guess we could say that it wouldn't have begun to run until the person found out about this, what they believe is a discrepancy in the person's licensure. But background more history than what I provided in the summary.
Do there continue to be benefits of the grandfathering, or or have those all expired?
It's all expired.
So what does it matter?
Right.
That's what I'm struggling with on this one is if there's no more benefit to the grandfathering and she's now had to go through the normal licensure, get the CEUs, pay the fees, do everything else, then it seems like within the 90-day period that the statute gives us jurisdiction for, he or she has done whatever they were supposed to have done under our statutes, and we can't consider activity that occurred 8 years ago.
Right.
That's not within our jurisdiction. My thoughts, you've got a recommendation to close.
That's correct.
Do we have a motion with regard to this case?
Make a motion, we accept the recommendation.
Second?
Second.
If the executive director will call the roll, please.
It was the will of the chair. We can also just do a general voice vote, just all in favor say aye, just since we don't have anyone calling in. If that's quicker, or I can
Okay,
do the roll,
all right,
whatever you'd like.
that's fine. All in favor?
Aye.
All opposed? The motion passes by unanimous voice vote.
All right, next is number 2 in the legal report, and that case number is 2017-10, and the recommendation here is to close.
As the respondent now incarcerated, should that be the complainant?
Yes, that's just
Okay.
I've flipped the.
Important things to worry about.
Yeah.
I make a motion to adopt the recommendation and close.
Second that motion.
Okay. We have a properly made motion and seconded to close case number 2017-10. All in favor?
Aye.
All opposed? Okay, the motion passes unanimously.
All right, number 3 in the legal report, case number 2017-11, and the recommendation is to close.
I move to adopt the recommendation and close the file.
Second.
Have a properly made and seconded motion to close case number 2017-11. All in favor, say aye.
Aye.
All opposed? Okay, the motion passes unanimously.
All right, next, number 4 in the legal report, case number 2017-12. The recommendation here is to close.
On the second paragraph, paid by the complainant's attorney, or is that correct, paid by the respondent's attorney?
It would be paid by the complainant, correct?
As a court reporter, we are not to supply anything to a non-party. So I would move that we accept the recommendation.
Second.
We have a properly made and seconded motion to close case number 2017-12. All in favor, say aye.
Aye.
All opposed? Okay, the motion passes unanimously.
And then number 5 on the legal report, case number 2017-13. Recommendation here is to recommend a consent order with a recommended civil penalty of $100 for unlicensed activity in violation of Tennessee Code Annotated Title 20, Chapter 9, Part 603 alpha.
This is a sticky one. It almost sounds like it's going to require a hearing.
It might.
If you accept his recommendation, of course, that authority would also come with, given the authority to set a formal hearing with the option for them to settle via consent order with a $100 civil penalty. Of course, as you all know, the maximum penalty is $500, so there can be some discussion as to that, if you all feel that there should be a higher civil penalty. But of course, that's Dennis's recommendation, as he has the knowledge of the facts of the case. I just wanted to point that out to the board.
I think the issue comes in is there can be a penalty per occurrence.
Transcript. Yeah.
And that might, quite frankly, that might require sending out for an investigation with that. That's a question we just don't know. We don't know how involved this individual is now whether they're still practicing. Of course, it may not matter if there's been however many before they stopped practicing. So that is an unknown as far as the number of transcripts.
Have they taken any steps to get licensed since the complaint was filed?
We've had that I might have to check with the full-time staff to see if there's been any steps, like an application that's been submitted, but as far as I know, there hasn't been.
Trouble I have would be with the amount of the civil penalty, and that, of course, we don't know whether these allegations are true, but if we assume for a moment that they are, the civil penalty isn't even the same as what the licensing fee would have been that they never paid. So they seem to be getting off with taking thousands of transcripts, and we're not even making them pay what we make the court reporters pay to get their license to do it the right way. I think, if I recall correctly, we have historically been fairly harsh on unlicensed activity, as that seems to be the principal issue that comes before us. I don't have a specific number in mind, but I guess I'm not comfortable with just $100 if I don't know how others feel about that.
Another question that I would have is, was this individual grandfathered and then let their license lapse? And if so, I think it should rise to the occasion that they want to be licensed again. They should have to apply for traditional. Grandfathering's gone.
Right.
And at this point, I will just, to speak to the license status, because they are already expired, they are outside of grace, so they would have to reapply to become licensed now and meet all of the.
I have a question. The $100 civil penalty for unlicensed activity, is this in reference to the one that the complainant provided, or is this civil penalty supposed to encompass the allegedly thousands of jobs that she or he performed?
Just the way I looked at it was just that the one complaint. We have one complainant, unlicensed activity. Certainly within the board's purview to, if we have more information about additional violations relating to more unlicensed activity, but for purposes of just a legal report, that was my logic.
That seems pretty light since it's a Class C misdemeanor. Can that not carry up to 30 days in jail?
I'm remembering my range. I believe that's right. A Class C would be 30 days. Yes.
I tend to think that the chairman is right on this, at least for the first offense. And we're talking about the one here. The civil penalty, in my estimation, should exceed or at least be equal to the fee that was avoided. Now, if we find out that there's dozens, scores, hundreds, or thousands more, you can't always take the principle that the first one is the highest fee, and then we just tack on a smaller amount for those. But we have to go into the assumption that maybe there's only going to be one deposition that is the subject of the complaint, and we know nothing of the other thousands. And if it is just the one, I wouldn't want $250 on thousands of them. That's clearly, I think, excessive. But if we're only going to penalize for one, I agree with the chairman. I don't think $100 is sufficient.
Would there need to be a complaint for each of the thousands of depositions?
Not necessarily. If there was evidence of others, I mean, when you say thousands, I mean, what does that even mean? I mean, that could be 1,000, that could be 25,000. There wouldn't have to be a complaint open for each individual one. It would be within the board's purview to.
I think what this comes down to is we have evidence of one violation at this point, right? And,
Right.
and there has not been an investigation into
Right.
the allegation that there are thousands other times that
right.
they perform court reporting duties. So we have to operate off the one piece of evidence that we have. So we can assign a value for penalty for that one violation. But if we think that we should open an investigation into this matter, then I think that should be
Yeah, we would need a motion to have your office open an investigation, correct?
Well, maybe at this point, I mean, we
A
could
more
just.
formal investigation.
It's.
Yeah, the easiest thing for you all to do would be to make a motion to have Dennis investigate that further and then re-present this case to you
At a
with
later
the
time.
results of the information that he finds.
Could we make as part of the consent order that this particular individual agree to not perform court reporting services without being licensed first?
A consent order that generally always has cease and desist language, and as part of our standard sort of template, so, right.
I got a question. As part of your investigation into this, did you ask the court reporter or the attorney for the court reporter, is this the only one, or did you all explore this allegation of others going on?
No, in fact, the response that we got from the complainant's attorney was that, like I said, there was no admitting one way or the other whether there were one or whether there were thousands. And in fact, I think the attorney was trying to say the individual has been ill for some time and was maybe trying to play on the sympathy of the board a little bit in their response. So, right, and so when in terms of investigations, our agency has we don't have investigators just for each specific board, but we have investigators that once we give them guidance, we give them basically a set of questions. Here's what we want you to ask, and send them out into the field and literally just find these folks. In this case, probably we'll end up going through this individual's attorney, which is pretty par for the course when it comes to any other board where we have an attorney involved, and ask them the questions. And that could be one of the questions of how many transcripts are there after this date? Because I believe 2016 is the time at which this person fell into an expired status and then continued to do.
Court reporter, a small operator, for lack of a better term, or?
I believe so, small to medium. It looks like that there are other people that are mentioned as being sort of part of an association. So I don't think it's a solo, but I think that it's small to medium.
Thousands sounds excessive.
In a year and a half.
Because
yeah.
3 depositions a day for that amount of time would be 1,185. That's not thousands. And that would be 7 days a week working.
Regardless of the allegation, I think that this complaint falls under the core purview of this board. So I think we have an obligation to proceed with an investigation, considering what we know at this point.
Is that a motion?
That would be a motion.
I will second that motion.
Okay, we have a properly made and seconded motion to ask council to conduct an investigation and represent this matter at the next board meeting. All in favor, say aye. Aye. All opposed? The motion passes unanimously.
And just by way of information for the board, because I know we don't meet again until September, if the results of Dennis's investigation show that there is an immediate threat in some way, we would have to hold a special meeting for a summary suspension. Well, we'd have to hold an emergency meeting for discipline of that, just because we don't meet again until September.
That legal had for the report?
That concludes the legal report, and I don't have any other business.
Okay, if we.
Just the only legislation we had, I can tell.
Okay, got it.
By way of legislation, the only thing that came up was the Board for Court Reporting came up for sunset. That did pass to extend it through June of 2024. That's public chapter number 519.
If we can move on to new business, we'll cover election of officers and anything else that the board would like to cover. But I'll just read the statute as a primer. TCA 20-9-604F states, at its first meeting each calendar year, the board shall elect a chair, vice chair, and secretary from its membership. No member shall be elected to serve more than 2 consecutive years in the same office. At the last time we did election of officers, that was March of 2017, and the following were elected their respective positions. That was Mr. Collins for the chair, Mr. Gibson for vice chair, and then Judge Rambo for secretary. So just kind of give you an idea of some.
Which are subject to being reelected, or who's?
You can serve in office in consecutive year after year, just not in the same position. So for example, if the 3 that were listed, they could serve again, just not in those positions.
I recall the statute allowing 2 consecutive terms, if I recall. Because I know Ken served as chair for 2 years.
2 different times.
Right, early on, and then
Right.
Towards the end of your
You're right.
term.
No more than
consecutive years.
Year,
Thank
isn't
you. Yeah,
I
that's
don't
correct.
even remember.
There has to be at least a year in between serving.
Yes, thank you. Thank you for that clarification. That is correct. So you could serve in the same office 2 years, just no more than.
Right. My question was Collins, Gibson, Rambo, any of those 3 precluded from one more term?
No.
Okay.
I make a motion that they all serve another term.
And you could do that in the form of a motion if you like. All right.
Okay, we have a properly made and seconded motion that I serve as chairman for another term, Ken Gibson serve as vice chairman for another term, and Judge Rambo serve as secretary for another term. All in favor, say aye.
Aye.
All opposed? Okay, the motion passes unanimously.
And then if I could just bring up one item in regards to, I'm sorry. One little quick item, and it's we don't have to vote on it today, but something just for food for thought. I probably could have put it in the director's report, but this seems like a great time to do that as well. Anonymous complaints. In the past, we've never referred those, and it has to be truly anonymous. There's just no information to follow off on. You know, if they give us a tip, but they give us something to work with, then we work with that. You know, some actionable information. We'll move on that. But if somebody makes just a wild accusation, but then there's no one to follow back on. There's no information to follow up on at all. Those just were never referred. Those are just dispatched. But what we're wanting to do now is we want to track those, and so we're opening those. but we don't have the authority to close those without the permission of the board. So if that's something that the board would deem fit, again, any anonymous or any complaints that have actionable information, we're going to continue to refer those, continue to work those. But anything that's not actionable, whereas those weren't referred before, we're going to go ahead and open those and then just close them administratively. But we can't do that administratively once it's open as a complaint unless the board grants us authority just for those complaints. Is there any questions in regards to that?
Give a more concrete example of the difference between the two.
Yeah, sure.
Want to make sure we're doing our oversight. Not that I don't think that y'all do a terrific job, but so what would be an example of what you would just administratively close versus what passes muster to come to us?
Excuse me, if we received a complaint that simply said there was an unlicensed court reporter at a deposition, period. We don't know who it came from. We don't know where the deposition was. We don't know when it took place. We didn't get a copy of a transcript. I think that's a case where we would want to open that and close it without bringing it to the board.
Excuse me, but I wouldn't consider that a complaint.
Right,
would
which
say
is why
that's
we
an
would want to
unfounded
close it, but that's the way the information would come to us. But if we get something more substantial, like I was at a deposition in this place, these were the attorneys, we at least have somebody to reach out to. And those are ones that would still be worked and would be presented to you all.
Okay, thank you.
To your point, that is an unfounded allegation, but that's something that's just, that's, again, not actionable. There's nothing there, but they'll use the complaint pipeline. So it finds its way into our, into our reservoir. And so we have to do something with it. Before it wasn't a complaint, so we didn't refer it, but we're going to open it as a complaint since they're using that pipeline and just closing it because it's not a true complaint.
I don't think we should have to spend money on things like that. I think
That's
it
the
should be
point.
a complaint, an actual complaint with someone's name signed to it, or we're going to be chasing all over the country, and it's going to be wasting resources and money.
And that was the point because legal, anytime they touch, well, just manpower in general is expensive. But when legal's touching it, that's a billable hour for it's just a wild accusation with no actionable information, and we're paying for that. So that was kind of the idea. That's why we wanted to, from an administrative standpoint and a budgetary standpoint, move on that.
Making the decision regarding those complaints.
That's typically done. If there's anything actionable, they'll do that in council with our legal division, and they can make that determination ultimately. If they have any question when those are received, then they're to consult a council, and then they'll make that determination ultimately.
If there's something as blatant as the example I gave you, they would know to go ahead and close that because there's nothing to look into. If there's some question, they would usually email me and say, I'm not seeing anything here. Before I close it, I just want you to take a quick peek at it. And so I would look at it and tell them, yes, that's not actionable. Go ahead and close it.
Still, there's money and resources involved if someone hasn't signed their name to a complaint. Open up something that could feasibly be too costly.
You feel like you are compelled to do an investigation of, you're getting some facts, but they're wanting to remain anonymous. What is the policy on anonymous, period?
There isn't a true anonymous. Sometimes if they use the pipeline, they have to put their name on it. To that point, it's not anonymous. Sometimes though, you'll get like an email but they didn't actually file a complaint, but you'll get an email through our customer service line saying this happened, and those are obviously, unless they give us a name, at times we can do like open up an administrative complaint if there's something actionable there. But typically we'll refer them to go to the complaint the hotline or the complaint line to get that started.
Like if they've provided their name, then yes, it's official. You have to act. I don't think that we need to be involved in the anonymous ones. If you get one that you think that's so reliable from email, from customer service or whatever, I think they should have the authority or ability, and we need a policy on this, that they could go ahead and pursue it. But
And I will say that this is not a common occurrence for this board. I can speak to some of my other boards. if we get a ton of information and they just choose to put John Doe as their name, we still look into those allegations. So it's anonymous in that sense, but we have enough information to actually investigate whatever the allegations are.
We're talking about anonymous complaints with no legitimate actionable information in them.
Correct.
And giving the department the authority to administratively close those complaints.
And keep in mind, these weren't referred before. You know, the board wasn't getting those type of complaints anyway. We're just, as administrative, we want to track them as a metric. But once you open it as a complaint, there's no authority to close that, you know. So that's the only difference there. Still not getting them. It's just as administrative action, we're just we're opening and closing so we can track it.
And it's been reviewed by legal.
If there's anything questionable at all, then yes, there is a consultation.
I think you all are on the right track, but my preference would be that it be reduced to a written policy on how you're going to handle these, that we get to sign off on too.
I would like the complaints not to be open if they're anonymous.
Sounds like we have some meat for discussion then. We don't have to make that decision today, but just to introduce it, if everyone was on one accord, then we would go ahead and vote on it. But since it sounds like we've got some different ideas, we can discuss that, of course. But we can also come back with some different ideas as well for meat for that discussion if you would prefer.
Sounds like that would be appropriate,
Okay.
given
So-
where we are today.
Well, so that was it then. Unless anyone had any other new business.
I do have a question.
Yes, sir.
Recommendation for us as board members, if we have a court reporter that comes up to us and says, I found out about this problem is going on, should we as board members make the initiative to report it, or is it appropriate for us to just look at whomever has this information that's bringing us directly saying, you need to report it directly?
I would direct them to file the complaint, because in the instance that it does go to a formal hearing, they may be called as a witness. And if you file the complaint, you would be listed as the complainant, and at that point, Dennis would be forced to try to question you, but that would be difficult as you're also the fact finder in that hearing.
And knock us out of being able to
Right.
vote on it.
I had to attend the sunset hearing for our board a few weeks back, and I can tell you that the General Assembly frowns upon very strongly board-initiated complaints against licensees and non-licensees, and that was raised several times with several of the boards, and they do keep metrics on that, and they're not very keen on it. So I think we should not wade into that water.
Right, I would just direct them to file the complaint. And it's fairly easy to do. It's available on our website. They can go in and click a button, and it's just a fill-in that they can complete.
Chairman, you're welcome to adjourn if you so see fit.
Do we need a motion to
Yeah,
adjourn?
let's go ahead and do that. We've been doing that with a lot of other boards just to so we can go ahead and wrap up business officially.
Okay, is there any other business? Okay, is there a motion to adjourn the meeting?
So moved.
Second.
Okay, we have a properly made and seconded motion to adjourn the meeting. All in favor, say aye.
Aye.
All opposed? Okay, we are adjourned.
Thanks for your help.